The Supreme Court just dropped a political nuclear bomb, igniting a case that could impeach the entire Trump administration. Yes, you heard that right. The same court Trump called a disaster is now turning its sights on his own power. The Ninth Circuit, the judges he mocked, attacked, and tried to crush, are suddenly back in play. The very walls of Trump's legal empire are cracking open. Grand jury secrets, Mueller's files, everything he tried to bury could explode back into the spotlight. This isn't just a legal fight anymore. This is a battle for democracy itself, and it just got personal. The Supreme Court just told the country something simple and profound. Even the most powerful defendant in America has to face the clock like everyone else. They refused to stop the New York hush money case from moving forward to sentencing. That matters, not because it ends the story, but because it proves the rule of law still has a pulse.
President Trump really dislikes these judges.
The Ninth Circuit is a disaster.
Nobody can believe these decisions we're getting from the Ninth Circuit. It's a disgrace. The Ninth Circuit, everybody knows it. It's totally out of control.
When Trump took office, most of the Ninth Circuit's judges had been appointed by Democratic presidents, and they overruled some of Trump's most provocative executive orders. The travel ban, emergency funding for a border wall, they all stopped here.
Very hard to win at the Ninth Circuit, if not impossible.
A big win for President Trump today as the Supreme Court denies Democrats access to grand jury material from Robert Mueller's Russia investigation, at least for now anyway. The court agreed to hear the administration's appeal of a lower court ruling that the documents be turned over to the House, which likely would not happen until after the 2020 election. House Judiciary Committee Chairman Jerry Nadler putting out this statement saying that he is confident Democrats will.
Here's the snapshot. After a New York jury convicted Donald Trump on 34 felony counts for falsifying business records tied to the 2016 hush money scheme, his team tried every emergency exit: delay in state court, pause at the U.S. Supreme Court, broad claims of presidential immunity. Each step was designed to run out the clock. Courts didn't buy it. Days earlier, New York's appeals court had already said no. No more delay. No special carve-outs. No pause button just because the defendant is a president-elect. That's the factual baseline.
Slowly putting new judges in the Ninth Circuit.
Trump has already added 7 new judges to the Ninth Circuit Court of Appeals. And by the end of his first term, there's a good chance that the Ninth Circuit could look very different.
Very eager to get their hands on these documents. These are grand jury materials and other materials connected with the Mueller report that have never seen the light of day. And what the Supreme Court decided this morning is it didn't resolve the case on the merits, but what it did say is that it won't be deciding the case on the merits until long after the election is over. In all likelihood, not until the year 2021.
And remember, this is the same Trump who has spent years undermining confidence in courts whenever rulings didn't go his way, especially the Ninth Circuit. He called it a complete and total disaster, out of control, but disgrace. That's not just bluster. It's part of a long political project to delegitimize any independent check on power. So let's be clear about the through line tonight: accountability versus impunity. If America is a nation of laws, then verdicts and sentences can't be optional for the politically connected. That's not lawfare. That's the law. New information reinforced that point this year. The special counsel's final report, released before inauguration, didn't mince words. It said, in essence, the admissible evidence in the federal election case track was sufficient to obtain and sustain a conviction. That's not partisan spin. That's the prosecutor of record putting his assessment on paper for history. Why does that matter here? Because it undercuts the narrative that any criminal accountability for a president is inherently political. We've seen courts across ideologies enforce limits before. Go back to the travel ban litigation. Whatever you thought of the outcome, the process showed the judiciary stepping in, forcing reasoned arguments, and setting boundaries. That's the system working. Arguments, review, rulings, checks on executive power. Let's walk the timeline of this New York case in plain English. January 8th, Trump's team rushed an emergency application to the Supreme Court. The claim? That sentencing a president-elect would harm the presidency and that immunity questions justified a freeze. It's a very big ask. leapfrog everything and stop a state law case after a unanimous jury verdict. January 9th, prosecutors answered, quickly and directly, telling the justices there was no legal basis to intervene and that sentencing should proceed as scheduled. In other words, let the normal criminal process continue. January 10th, the court denied the stay, and then at sentencing, Judge Merchan imposed the most restrained outcome available under New York law, an unconditional discharge, a formal judgment of guilt with no jail, no fines, no probation. That last detail is inconvenient for those claiming a witch hunt. If this were vengeance, the judge had tools he did not use. Let's pause on that. Accountability doesn't always look like handcuffs. Sometimes it looks like the system drawing a line, logging a conviction, and refusing to bend the timeline to politics. The message isn't lock him up. The message is simpler. Powerful people don't get a separate calendar. Now, you've probably seen sensational thumbnails saying the Supreme Court ignited impeachment against the entire administration. That's not what happened. The justices weren't launching impeachment. They were adjudicating an emergency request about a state sentencing. Different branch, different process. When politicians and YouTube grifters turn routine judicial orders into apocalyptic claims, they're not informing you. They're trying to make you feel helpless and angry, so you'll stop trusting any neutral umpire. Thread the through line again. Impunity thrives on confusion, on purpose. Attack the court, attack the press, attack prosecutors, anything to make the facts feel optional. But the facts here are straightforward. A jury convicted. Appeals were filed. Courts, state and federal, declined to collapse the schedule. The sentence, ultimately, was minimal. Yet the precedent stands. Being president-elect isn't a magic shield against a state court's ordinary business. Zoom out. We've watched a years-long pattern demand loyalty oaths from institutions, cast independent judges as enemies, and insist that public accountability is a partisan conspiracy. Remember how the Ninth Circuit became a punching bag precisely because it reviewed the travel ban and border funding cases? That wasn't about jurisprudence for Trump world. It was about power. If a court can stand in the way, it must be delegitimized. And yet, institutions pushed through. Conservative and liberal judges alike have issued rulings that cut both ways for Trump. That's what independence looks like. You don't always win. You get reasons, you get timelines, you get rules. Here's where it hits home for you. If courts cave to political pressure, it won't just affect one high-profile defendant. It reaches into your life, your vote, your privacy, your rights at work, your protections against government overreach. Judicial independence is not an academic virtue. It's the guardrail between you and someone else's unchecked power. Now the stakes escalate. 2026 midterms are coming, and the lesson from this sequence is that delay is the strategy. Drag proceedings past key political moments, then claim the people have spoken, so accountability must wait. That is not how our system works. Elections pick leaders. Courts apply laws. Neither cancels the other. If a jury says guilty and a judge schedules sentencing, that schedule shouldn't bend to a campaign calendar. One more point on rhetoric. When leaders call courts disgraceful or out of control simply because they disagree, it's not just venting. It's instruction. To followers, to media allies, to anyone inclined to harass judges and clerks. We have seen where that escalation leads. Threats, doxing, and a chilling effect on the people who keep the lights on in our democracy. The climax of this story isn't an orange jumpsuit. It's a civic lesson. We either defend the boring, unglamorous mechanics of justice, or we lose them. No algorithm will reward that message, but the country will. So here's where we land. The court's refusal to stall a state sentence did not ignite impeachment. It affirmed something quieter and more durable. Deadlines apply. Verdicts matter. And despite a constant barrage of attacks, the judiciary still shows up. That's worth defending. That's worth voting for. And that's worth remembering the next time someone tells you the law is whatever the powerful say it is. Through line, one last time, accountability over impunity. Not because we hate anyone, because the Republic depends on it.